That is your last statement. I beg to mention item 12. With the consent of the other side, my lord. My lord, may it come up after view vacation, my lord?
You have taken consent of the other
Yes, sir. Other side is there.
consent of the other side. Take it up. After view vacation,
View
you
vacation.
think? Fixed date you want, or it will become after view vacation?
My lord?
In the third week of January, we can first. You want a fixed date here? You want a
Yes,
fixed date?
20 January.
2021, 22, my lord.
20 January.
And if it
Any day, my lord,
Yeah,
20,
mainly.
21, 22.
20 mistake. January.
20?
Yes, sir. All right.
Lordship, with respect to item number 14, Lordship, I pray for today's accommodation, Lordship. And I have taken consent from the opposite party, Lordship.
You are for the petitioner or the
Petitioner,
respondent?
Lordship. Petitioner,
Petitioner.
Lordship. Petitioner.
Consent has been taken?
Yes,
for the
yes, Lordship.
Same order.
After 4 weeks, Lordship.
After 4 weeks.
Lord. Available.
And let's see, these are all 15 matters, in fact.
Lordship, Lord.
So, let me finish.
Available.
May I please, Your Lordship? I beg to, for item number 5, Your Lordship. Your Lordship, the appellant has taken the brief from us, Your Lordship. And Your Lordship, and also he has issued a letter also, Your Lordship. The letter is with the counsel M.K. Sharma, Your Lordship. And he's out of station, Your Lordship. Kindly 1 week time may be given, we will produce the letter.
Who took the brief? Your petty appellant?
Yes, sir. Appellant has taken the brief from us, Your Lordship. We are no longer in the matter, Your Lordship. And Your Lordship, Your Lordship, he has also
Have you
given.
finally furnished the copy of the notice that you have taken, issued notice to your client and all?
Yes, Your Lordship. The letter is with the counsel M.K. Sharma, Your Lordship, and he's out of station, Your Lordship. Kindly 1 week time will be given. We will show the letter. We will produce a letter to this court, Your Lordship, on the next date, Your Lordship.
I will speak matters are take my lord. Take matter.
2 matters are there. Your
I
Lordship.
will.
Six, Mr. Bora was there, AM Bora.
Yes, Your Lordship. I have asked Your Lordship, the appellant expired yesterday, has stated, Your Lordship. They will.
In which,
The
in which
appellant-
item? Item number 6.
Yes, Your Lordship. They stated the appellant expired. They will come today and say that to the death certificate, Your Lordship. I was informed yesterday like this, Your Lordship. I'm for item number 5.
No, you're for the item number 5, and
Yes.
item number 6, you had the information that the appellant died.
Yes, Your Lordship. Oh, Your Lordship, as the matter will reach, they will come, Your Lordship.
Okay, 6, we'll call it at the time of. Though it is along with 5,
5 years.
still, let's see. No, I'm segregated. No. Just for a wait for some time.
Yes, sir.
It will reach by
Okay.
very recently.
Obligation.
May it please your lordship. Lordship, this is concerning item 4. I just want to peruse the file once, if your lordship allows.
Item 4.
Yes. I just want to peruse the LCR once, since one of the document that I'll be relying on is missing in my file. I'll just have a glance at it
Office
once.
hours only, you can.
Right now, lordship.
Considering the detention of the petitioner and the grounds of arrest of the petitioner, on last occasion, your lordship was pleased to call the status report of the trial court case. So status report.
My lord, here earlier, Lordship was pleased to reject their petition, my lord.
Subsequently, they have
Rejection order is at page, my lord, 28, my lord. It was rejected on 6/8/2025, my lord.
Ah.
And in the last occasion, Lordship was pleased to call for updated status, my lord. As per status, my lord, only IO is to be examined.
only I used to be. The rest of the witnesses are already
Okay.
been in. So your petitioner is in custody since when?
more than 2 years. 28 November. So far as my lord, this IO, Mr. Midul Hazarika,
Huh.
was called for 21/8 of this year. And thereafter 4/9/25, 18 September 25, 3rd October 25, 16 October 25, 30 October 25, 13/11/25, and 27/11/25. So remaining
Yes, yes,
consecutive,
just repeat the dates.
consecutive 7 dates.
7 days.
He is absent.
My lord, next date is fixed on 6/12, my lord.
Tomorrow.
Day after tomorrow.
Day after.
6/12, my lord. It is also in a Lordship kindly pay status report, my lord. Here it is said that, my lord, someone issued to him, my lord.
But otherwise, as per his submission in 7 consecutive dates,
My
it
lord,
has
he-
been fixed for IO, but he remain absent.
my lord, that I have not found.
But otherwise also it seems that the court took all NDVR because from 21/8/2025 till date, if 7 dates has been suppose, so many days has been fixed by the court.
Right.
So, I mean, court took all the NDVR to this finish the also took for the conclusion of the trial. It seems.
Right.
Yes, Mr. Paul, any other submission?
My lord, my main submission is that on the basis of grounds of arrest, which is illegal and not in conformity of Article 22, one of the Constitution of India, and the other laws laid down by the Honorable Supreme Court recently time to time. And so far as the last judgment I have relied before your lordship, that was Ahmed Mansoor or something.
Yes,
And
Ahmed Mansoor.
on that case, my lord, every aspects of the with regard to arguments of the prosecution side had been already been clearly discussed. So from that point of view of the matter, and I should be granted bail by stringent conditions. And so far as with regard to the task of prosecution side, they may take its own course after, because as the arrest had been found to be not in conformity with the constitutional mandate and other statutory laws of section 36 of new code BNSS and 47, 48 of BNSS. So considering this aspect, I should be gone bail by subjected to stringent conditions, because I am a local resident, and so far as I am like to abide by any terms and conditions to secure my presence before the learned trial court. And the remaining part is that due to having detention behind bar since last 2 years, my lord, I have not been properly consulted with my lawyer. That is also one of the important aspects of criminal jurisprudence, my lord, with regard to undergo trial prisoners. And that apart, my lord, on last judgment, very recent judgment, Honorable Justice, Chief Justice of India, Gawai, led another division bench, held that when arrest has been found to be not in conformity with the constitutional mandate, any accused can be released on bail, subjected to further course of action on the part of prosecution. They may have liberty to take appropriate action for to comply with the arrest and appropriate action for cancellation of bail or to seek custody of the accused person further. That has been laid down by the new judgment. It is a 53-page judgment, which is not my learned friend may avail it. I have not online. So every remedy is in the hands of prosecution, because when arrest cannot be excluded from the trial part, because first of all I was arrested, thereafter all legal formalities have been commenced, including filing of charge sheet and other. But when arrest has been found to be not in conformity, then other aspects are inconsequential. So far as this petitioner belongs to a very middle class family, and he has 3 childs. By any condition, if any I have been convicted after 6 or 4 months completion of trial, then law will take its own course. If I acquitted, then it's no matter.
My lord, my submission is the lordship was already discussed in the earlier rejection order, my lord. Bihan Kumar and Prabir Purvastha. It was already discussed in the earlier rejection order, my lord. Thereafter, it was come to the point that, my lord, it was recovered from the conscious position of the accused person, and on his leading, some materials were again recovered from the house of the accused person, my lord, from leading, my lord. Then after discussing all this, lordship was pleased to reject the petition, and here at that time, my lord, only out of 16, my lord, 13 witnesses were examined. At present, as per my lord, lordship, kindly please here, my lord, status report, my lord. only IO is to be remain examined, my lord, and that is fixed on 6/12, my lord. And at this stage, my lord, the last stage of the my lord, trial, my lord. And from the record, I also found that he is not the permanent resident of Assam, my lord. He is from Bihar, my lord. And subsequently, he is here temporarily remaining in the Dharangiri, my lord. And there is a big chance of absconding, my lord, away from the trial.
My lord, there are so many persons have been granted bail by this honorable
That is
court.
different thing, my lord. Because two
Despite
times
being
perhaps it was rejected.
resident of the others outside, whatever may be, he is the worker working within the same area in a pharmacy, my lord. So there is no scope, and he is residing since last 10 years in the said locality.
Ihan Kumar Purvi was already discussed in the earlier rejection order. Earlier 2 times it was rejected.
That is on
And
record.
it was with a commercial quantity, huge quantity, my lord.
My lord,
And-
I have supplied one judgment of this honorable court, the recent judgment order in paragraph 3, my lord. In this case, the said accused person has already been uh, uh, detained due to some conscious possession of the contraband. But considering the aspects of not in conformity of the grounds of arrest, this person has been granted bail by this honorable court, by a coordinate bench of this court. So, my lord, whatever it may be, the conformity of the constitutional mandate is should not be superseded by other aspects of any case. My limited submission before your lordship.
My last submission is that Lordship may next date is 6/12, my lord. Lordship may I pray for wait for that my lord, on that Lordship may call for whether on that day I will examine or not, my lord. Only on day after tomorrow.
Already 2 days, most probably status report we call.
Mine.
First day order will see to it. First day order.
My lord. And at the last stage of the my lord, trial, my lord, only IO is examined. Is it to be examined. And other witnesses implicated, all of them.
Implications are there.
So far as my lord, the PW 10, my lord, the house owner of the petitioner has been declared hostile because he denied that he is residing in that house where a contraband was recovered. In cross-examination part of the PW 10, my lord, your lordship will find. And so far as other independent witnesses, all have been stated that they have not seen the occurrence. So far as I have gone through limited query of the trial deposition aspect. And only official witnesses are saying that he's been found conscious person, but senior witnesses has denied his involvement in this case. So far as house owner also said that this house not belongs to, and he never resided on that house. He resided in other house where contraband recovered.
For this
So
purpose,
for
also-
that reason, my lord, PW 10, the Anandaram Borough has been declared hostile by the prosecution.
for that regard also IO, the position of IO is also necessary.
Necessary, definitely, but lordship, I leave up to your lordship.
My objection is that my lord, at the last stage of the trial, my lord.
So far as
And already
this bail application is not on the ground of any quantum of witness, only on the basis of grounds of illegal arrest, not on other aspect. So that is,
It was already discussed in the earlier rejection order.
but it can be. Problem.
May I please, Lord? My lord, here in this case, I am behind the bar since 88 days, my lord. Admittedly, so far as the FIR and forwarding report, some money recovered from the house of the accused person. So 88 days, my lord, only 2 days to complete the mandatory.
Yes, do you have any information here?
My lord,
He is in custody saying for 88 days.
my lord, my lord. And my lord, here lordship is this is the case where 2 crore rupees were stolen from a doctor. Lordship is my lord.
My lord, Chamur petitioner was earlier granted bail by your lordship, my lord.
Oh, yes, yes, there
My
are
lord.
they purchased something.
My lord,
My lord,
several
some
vehicles, land.
One Alto car.
Uh-huh. This
Earlier
man
also done.
spend money lavishly.
My lord, purchase land
Only 2
and
days.
3, 4, 5 vehicles.
Only one vehicle.
No.
Alto vehicle.
One Scorpio, 2 Alto, 2 Magic, purchase 1 quota 9
Hmm.
acre land.
Your present petitioner's name is?
My lord Jahangir Ali.
Yeah, he is the.
My lord, main person.
Anyway, but the question is that whether there is any probability of filing of the charge sheet.
My lord,
My lord,
Because-
if diary is available before this.
no, that is not the case, my lord. But I have the strong objection, my lord, in this regard. If sufficient materials are I was collected, my lord. If lordship rejected, then it will go to the my lord whether they can submit charge sheet on today. 2 days already yet to be, my lord. And today is it. They may file also supplementary charge sheet also, my lord. Day after tomorrow, my lord. But some of the amount is yet to be recovered. Huge amount, my lord. Lordship
I will
kindly
participate with the investigation agency for revealing investigation at any stringent condition. I will participate.
But my objection is there, my lord. As
Administrative Paramati done it. So had Mr. B. Sharma done an additional PP. An application. It is submitted to Mr. Paramati that the present accused petitioner is as alleged the however, presently the accused is in custody since 88 days and hence, considering his lengthy detention, he may be released. Whether he submitted that he being a permanent resident address locality will appear before the IO as and when his cooperation will be needed. Next para, Mr. Sharma, the learned editor PP submitted in this report that the bail application for the present this petitioner was earlier rejected and present of his death. And there are sufficient incriminating materials against him, who is the main kingpin of the entire case. Mr. Sharma further submitted that this earlier bail application is that there is no new ground for the present bail application which was rejected by this court. Mr. Sharma accordingly raised payment of it and submitted that the petitioner may not be allowed to be bail at this time. Next, during the submission made by the that stop. It is admitted that the earlier bail application of the present petitioner was considering the incriminating
my lord, his bail petition was rejected, my lord.
Earlier was
Accused
not rejected.
bail petition was rejected earlier. After going to the airport,
This
my lord.
petitioner's bail was.
Absconding, my lord. He was absconding, my lord.
He was absconding.
My lord.
Then
Well, arrested.
subsequently he got arrested.
Subsequently,
My lord,
subsequently
subsequently he was
arrested.
arrested, my lord. Arrested
Earlier-
person was, my lord.
Co-accused person's bail petition was rejected. This petitioner not come. This petitioner come first time before this.
No, whatever, when he got arrested.
My lord, 8-9, my lord. 8-9,
8-9.
2025.
No. Subsequently arrested, my lord.
Hamsher Ali is Buffett. So, petitioner this petition.
Only
Decision Jahangir.
আর বাকি তেখেতৰ সাবমিশন আর্লি বেল অ্যাপ্লিকেশন এটা না লাগে গেছে খালি মেট্রো সাবমিট hearing this subsequent of query it again practical যিখিনি reveals that IO has collected sufficient incriminating materials against the present petitioner and it also reveals that the bail applications of other co-accused persons was rejected considering the maintenance this time. However, it is seen that the accused petitioner is in custody since 88 days and on an inquiry it is submitted by Mr. Sharma that probability of submitting the charge sheet within this statutory period is also not there, but parameter. Next one, considering the submission made by Lara without going detail into the merit of the case, only considering the length of detention undergone by the accused. I found that sufficient opportunity, the IO got the sufficient opportunity interrogate the accused petitioner, keeping him in custody. And hence, further custody interrogation may not be required. However, the petitioner is hereby directed to extend his cooperation as and when it is required. Whose satisfaction it is?
CGM Porpeta, my lord.
CGM Borpeta
My lord.
to the satisfaction of CGM. Yeah.
Highly obliged.
Oh, itu gusi gol gusi. Itu. No, no, more. Iya, iya. Oh, no, no, ada no, ada gusi. Kan gusi gol mutu. Right. Yes,
Oh.
item number 2.
My lord, here we have received one report from the my lord IO concern, my lord. It has handed over to CBI, my lord. Then CBI will appear, my lord. Then CBI.
So you're appealing then.
In this matter, my lord, I was given interim protection and the CD was called for.
Yes, what do you want?
Lordship, we have got to know yesterday only that the case has been transferred to CBI. So,
So now, if suppose we call for the case diary also, in that case, the new your case number will be different, I think. Now,
RC.
Yes, it will be RC case.
C.
It will be RC.
but present we don't have any.
Let them produce the case diary, my lord. Let the produce the case.
Hard MS, you are Mr. MS
N. Chaudhary.
and Chaudhary appearing on behalf of M. Kumar.
MS M. Kumari.
MS M. Kumari, the learned standing counsel CBI, and also heard Mr. M. K. Chaudhary, the learned senior advocate, assisted by
T.N. Srinivasan.
T. N. Srinivasan, a counsel for the petition. CD not received. However, it is submitted by Mr. Sharma, the learned counsel, learned in people that case has already been handed over to CBI. Accordingly, CBI. In that context, MS Chaudhary submitted that they will produce this CD in the next list the matter accordingly when it will be able to furnish
After vacations, Your Lordship.
vacation at date of 8th of January,
Any date from
8th of January, so and so. Interim be continued till next day.
my lord,
Pleasure.
that the interim has to continue.
Interim will continue.
And your lordship will direct that, my lord, the name of the CBI council is also reflected in the call.
Yes, yes, sorry. The registry is also hereby directed to reflect the name of the CBI council in the next list, in the context.
Highly obliged.
Sir, 4, 5, 6 marketing. Time lagi.
Your lordship,
Yes.
matter may be passed for time being.
You have gone through.
Lordship, although I could not find it there, I could not somehow, I did it very quickly, so I could not, otherwise I'll do the hearing, Lordship, not an issue.
That document is also not available here.
I think so. I quickly perused the document. I did not get much time, but I think the exhibits that are part of the LCR
Huh.
Before the trial court,
Yes.
that I think I could not find in the file. So far as the
Mr.
LCR
Sharma,
of
have you, who is appearing in this case?
the NI case,
Oh, NI.
yes. Service was complete way back in 29/5/2014. If your lordship will check that order, none had appeared. So matter was fixed for hearing in usual courts.
It seems there's an order of this completion of the service,
Your Lordship.
but he serving. Many services completed. State is a merely formal party.
Your Lordship.
Yes, this is against what? Equitable.
Against acquittal, Lordship. So first in the trial court before the JMFC, there was a judgment of conviction. Against that, the respondent had preferred an appeal, which wherein the conviction was converted to acquittal on a very technical point. And against that, we are here before your Lordship, challenging that judgment of acquittal.
My lord, against the appeal against acquittal, my lord, perhaps their attendance is necessary, my lord. It is the acquittal, my
It
lord.
is against acquittal.
Acquittal.
Against acquittal, Lordship.
Against acquittal, my lord.
Then too it is necessary.
Right.
See, this is of case of 2014.
My lord.
2000
And from the orders and the office note, it reveals
Okay.
the service was completed. But I have rightly
Knowledge
pointed out that
नहीं बोलेंगे advocate.
No, advocate आहे ना सीधा. Like till sessions they were there. Otherwise, they are aware of the matter being pending.
because it is
Both
an against
are
acquittal, so hearing other side is required.
Right.
Because if suppose any order is passed against them in their absence, it will be passed.
My lord,
So
that is
completed.
acquittal.
Otherwise, you were rightly pointed out that service is completed and that's
Yes.
why the matter is fit for hearing.
Right.
That is already there.
It is there at that time, my lord, at that time. But thereafter subsequent, they have not yet. That's my lord.
Who was the advocate? Suppose do you have any knowledge? Who was the
Lordship,
advocate?
back then even I was not in practice. 2014.
Yes, yes, you are also not.
But otherwise, there was a clear-cut attempt to evading trial. They are very well aware of the matter being pending. Service hence was complete also. Despite that, they did not appeal. And both the
Take one more chance now. See, isn't it?
Lordship.
Because for the ends of justice, not
Lordship,
otherwise.
Lordship.
Heard Mr. Y. Kothari, Dilan Company, appellate, Mr. B. Sharma, Dilan Edition, BP, appealing the cases before hearing and the from the record as well as from the office note, since that service was seems to be completed in the year 2015. And but as is submitted by Mr. Sharma, the learned edition, the present appeal is against the order of hence the presence of the respondent is required for the hearing of this case. In view of this, as well as for and also for the answer of justice, let fresh notice be issued to the respondent. This address is proper and correct, na?
Lordship, I'll verify once again if required.
Yes, sir. The proper and the present address of the respondent. Both the address you take to register as well as the
Lordship,
usual process.
Lordship.
And cases of this Kamrup Metro or
Yes, come.
Kamrup Metro?
Yes.
Video. Please do matter immediately. No, immediately not. After 4 weeks. Take a sense
Lordship.
after 4 weeks. You just take
I'll take
address
steps.
and see if the addresses have been changed and all, because this appeal is of 2014.
2014,
So
Lordship.
case may be of as per your
2008, Lordship. 2008, it was instituted. Then the appeal, then there's the second stage.
at that time, what was the age of the respondent?
Lordship, nothing that the check.
No, age.
Oh, age was 55 as per the records that I'm seeing. So, yes, even I,
And that
the
is
thought
one of
crossed
the
my
appeal.
mind.
So just make an inquiry.
Lordship,
Okay.
Lordship. Deeply obliged.
Number 5 and 6.
Yes, for 5, they have one prayer.
Lordship.
And for 6,
And for 6, we have appearing Lordship,
Uh.
but our matter become infructuous Lordship as the appellant already expired in 2019.
to that effect, have you furnished any death certificate or no? Thereafter, Mr. Sharma, is there a requirement of any other verification? No, I don't think. If appellant has already expired. Now that is
It
your
may
their
be 4
case and
years, no?
she's they're submitting that.
2019 of it.
It's okay then, we can, this may become infraction. Okay, now for 5, you are seeking an adjournment.
Yes, sir. But for 1 week, Your Lordship, we will produce a letter that he has taken the brief from us, Your Lordship. 1 week time may be given because the letter is with Mr. A.K. Sharma, Your Lordship, the council.
You are Nazneen, na?
Yes, yes, S. Nazneen.
Hard F5 to tick, hard MS S Nazneen. 5 6 bele bele kori ba. Nazneen Tilan Planet appellant appearing on behalf of Mr. M.P. Sharma. And also heard Mr. P. Sharma Tilan appearing. It is submitted, Ms. Nazneen, that the appellant has already taken, already took back the brief from this council. And in that regard, and to that regard, they have also issued notice to the appellant. However, they could not produce the, she could not produce the copy of the notice today as it is with Mr. M.K. Sharma and his counsel. In view of this, let the matter be listed 1 week as soon as it will be query raised, enabling the councils to produce the notice which was issued to the appellant. List account. Or itu dah criminal appeal 622. Hard MS. PMS.
C. Chaudhary.
Hard MS C. Chaudhary, the learned counsel for the appellant. And it is submitted by her that during the pendency of the present appeal, the appellant had already expired. And to that effect, she also produced one death certificate of the appellant, namely, he was Trolukonath Mohan.
Trailokonath Mohan.
Dr. Dr. Kunalage, Trolukoman Mohan, and this party death certificate. The appellant died on 1/5/2009.
1/5/2019.
And the death certificate was also issued accordingly on 15/5. In view of this, the present appeal has already become already disposed of. And
Lordship.
keep the death certificate submitted by the appellant in the case report as a part. No, no, it's I got a request. It's okay. Let's three. Timing was 3.
Item 3, Lordship.
Yes, 3.
My lord, in this case, my lord, LCR, my lord, only trial court record of learned sessions has been received, Lordship. The record from this learned CGM is required by in this regard, my lord. The LEC order dated 3/11/2025, Lordship.
Those deposition part and all are not received.
That required record is very much necessary because of my lord.
So even after
perversity.
the there's an order, detailed order
Yes,
of
my lord.
3/11.
Yes,
So Resti did not take any step or what?
my lord. In fact, in last part of the order, I think my lord at 2 p.m. something was taken.
And yes, registry was directed to release the matter on 6/11/2025 at 2 p.m. along with the said report. So what seems that on 6/11, uh, the registry has called for the TCR, but same has not been received. As per 6/11, the registry took the steps and called for the TCR, but that has not been received.
TCR received only the session code TCR.
Yes, it's only session code. From the trial court, it has not been.
Yes. That is required.
Then what is this? On 24/11/2025, another order is there, where the question of receiving or non-receiving of this trial court records are not there. Why? In 7/24/11.
My lord, because those orders were, my lord, not raised by this honorable court. My lord,
No, but you were there.
earlier orders, lordship. I had to, my lord, inquire into them, verify the record, lordship. I have found, my lord, this, my lord, record was already called for, lord. I was given time to verify the record, lord. Record of this honorable court.
My lord, I think my lord on 24th, my learned friend was granted time to go.
Yes, lord.
And this matter has been listed today.
Yes, lord.
So it has been found that my lord, the trial court report has been received. If I'm not
Yes, that is.
So then on perusal of order, after perusal of the record, then only you came to know.
My lord, no, it was, I could know earlier, lordship. There are several orders, lordship.
No, order is there.
Yes.
3/11 is specific order is there. I have already seen.
So I have
On
just,
24/11.
I have just verified the earlier orders, lordship. So, my lord, that record is required, lordship.
No, obviously it will be required. It will be required for us also.
Yes, lord.
For the court also. But Mr. H. Learned counsel for the petition. So, but Mr. R. Kaushik learned additional PP appearing on behalf of the respondent. It is submitted by both Mr. Ahmed and Mr. Kaushik that this court call for the report case record, that is the record from Chief Judicial Magistrate Kamrup Metro, being numbered as GR number 585/1995. But till date, it has not been received by the registry. On perusal of the record, on perusal of the record, it reveals that by order dated 3/11/2025, this court called for the case record, and the registry was also asked to submit a report on 6/11/2025. But from the report submitted by the registry, it is, and from the order dated 6/11/2025, it seems that the record is not yet received by the registry, though it was called for by the consent section. Next, right, it is submitted by both the learned additional PP, Mr. Kaushik, as well as Mr. Ahmed, counsel for the petitioner, that the trial court record will be required for hearing of the present case, as all the evidence is there in the record of trial. In view of this, the registry is hereby directed to take immediate steps, call for the case record of so and so from the court of Daniel Additional CGM, CGM, Chief Judicial Magistrate Kamrup M. And to please the case. Do you want here any fixed date here? Because it is a very old pending case, 2010.
That is required.
After receiving the, my lord, LCR, it may be directed to be listed, lord. Otherwise, my lord, purpose will be served.
So otherwise, lordship can pass an order fixing a date and directing to place a record of that date, because it seems, my lord, several order has been passed.
Hmm.
But receiving the record means the earlier also that kind of order was
That
passed.
may not be, yes,
May
yes.
not be-
So better to fix a date. I think. The episode, immediately after vacation, we can fix a date.
Yes, ma'am.
7th of January,
Right.
7/1 2010. Actually, what had happened, this case is very
Old.
It could not be traced out, I think.
Yes.
So, but the report should be there, na? Proper
Yes,
report should be there, why it is not there. And all the records are already been digitized, in fact. So, therefrom also they can,
Yes, yes.
if required, can manufacture the document or not.
Well, there is an order of this honorable court, my lord. In that order, my lord, it is reflected, my lord, the registry, the learned CGM reported that the record was already, my lord, before the learned sessions. That was not returned. That is reflected in some, my lord, report.
That means after disposal of the that said appeal, it was not returned.
Yes, lord. So for my,
Then give us a proper report there.
Yes, yes.
Then we may direct the
any of the
concerned-
record should be, well, submitted by, sent by the learned CGM court.
see then. See. Okay, then.
Yes.
We are fixing it on 7th of January.
Obliged, lord.
Here, CBI, I mean, it is there again. And CBI.
Appeared.
Mr. Kyle has already sent the absent letter. None has appeared on on behalf of the applicant. However, Mr. S.C. Kyle is standing. However, Mr. S.C. Kyle has already sent the letter of absence. In view of this, let the matter be listed after 4 weeks as an identity by the registry. However, most of both the parties are hereby directed to proceed with the hearing on the next date.
May I please, your lordship, my lord? My lord,
You are appearing in all 8, 9, and 10, all the matters, na?
all the matter, my lord, the same, all the matters same, my lord.
Same, yes.
My lord, petition number 2,
In item number 9,
number 8, my lord, Himanshu Ranjan Saha, I need, my lord.
petition number 2,
Petition number 2, is sawmill, my lord. Himanshu Ranjan Saha, 698, my lord, item number 8, my lord.
yes.
Bharati Industries, my lord, that is petition number 2, hearing. It is sawmill, my lord, it's run by the petition number 1,
Oh, it's a sawmill.
sawmill, my lord.
Ah.
With effect from 17/12/1999.
It was run by whom?
It was run by the petitioner, my lord. Petitioner is the petition number 1, Himanshu Ranjan Saha.
He was running this sawmill since?
she was running the sawmill. But this case is
Since when?
till 17/12/1990, from 17/12/1999, my lord.
17/12/1999.
99, my lord.
Ah.
Please peruse Annexure 1, page 14, my lord.
In item number 8.
8, my lord. Page 14, my lord. My
Yes.
lord, first, the Government of Tripura, Factories and Boiler Organization, Department of Labor. Then there's a registration number so and so, PCB so and so. License is hereby granted to Himanshu Ranjan Saha, occupier, MS50 Industries, my lord. Valid only for the premise described below for use of factory employing not more than 9 person on one day during the year and using the motor power not exceeding 35 HP. My lord, on that day, my lord, 9 person can employ in the factory, my lord.
And as per the license, 9 persons can be employed.
Employed, my lord. Then, my lord, annexed to next page, my lord. 15. In the license to work as a factory, my lord. 2008 and 9, my lord, maximum number of worker on any day 9%, my lord. Profit got it. In also annexure next page, annexure 2A, 2011-30, 9%, my lord. Is employed, my lord. My lord. My lord, the media of the petitioner has never employed more than 9%, my lord. It is seen from the annexure 1 to 3. Therefore, it does not fall under section 212 of ESI Act 1948.
What is
Section
submitted?
212 of Employee State Insurance Act 1948.
Yes.
My lord, section 212 says that ESI Act, my lord. Factory means any premise, including the precinct, and therefore thereof whereon 10 or more persons are employed or are employed on any day of the preceding 12 months, and on any part of which a manufacturing process is being carried on or is ordinarily so carried on, but does not include a mine subject to the operation of mines act. That means, my lord, to fall under ESI Act in a factory, more than 10% or more should be employed, my lord. Then, my lord, comes to annexure 4, my lord, page 19. My lord, a show cause notice for non-compliance under the provision of EISA Act 1948 and regulation framed thereunder as amended up to date 1948, my lord. Annexure 4 till 19, my lord. The proposed notice has been given by Employment State Insurance Corporation, my lord, for non-compliance under the provision of ESI Act, my lord. May I allow to lead, my lord? Yes, your factory establishment, head office of the factory under the name and style of Mrs. Bharati Industries situated at Amtala near High School, Agartala, is covered under the purview of the ESI Act and regulations framed thereunder. And the code number so and so has been allotted to the factory establishment head office of the factory. You being the owner, partner, occupier, director, secretary, manager, and person responsible for supervision and control of the factory establishment head office of the factory, and therefore being principal employer, are required to comply with the provision of ESI Act and regulation in respect of the factory establishment head office of the factory. But it is observed that you have failed to make the compliance as mentioned below. Payment of rupees 54,382 only, deducted as employee share of contribution from the age of the employee for the period April 2000 and so, my lord. Number 2, my lord, payment of 1,47,660 as a payable as employee share of contribution from the salary and wage of the employee for the period April 2011 to March, March 2011, my lord. They have given a show cause notice for non-compliance of the provision of ESI Act. Subsequently, another show cause notice was given on 23/11/13, which we could not annex, my lord. I had to reply to question. My lord, in Annexure 5, we have given the reply to the show cause notice, my lord. Annexure page 25, my lord. In the reply, we have specifically pleaded that we do not come under the purview of ESI Act, my lord. In number 2, my lord, that Mrs. Bharati Industries not come under the purview of ESI Act because of the fact that according to definition of section 2 of subsection 12 of the ESI Act, factory means any permit that we have read earlier, including the fishing thereof, wherein 10 or more persons are employed or were employed. In this regard, I submit that there is less than 10 employees in my establishment, and to that effect, the license by the factories and boiler organization by registration number so and so date, wherein state there is none number of employed, my lord. My lord, got it. In the reply, we have given less than 10 employee has been employed in our factory, my lord. My lord, please turn to page number 31, Annexure 6, my lord. In Annexure 6, my lord, warrant of arrest, notice to show cause why a warrant of arrest should not be issued, my lord. Whereas you fail to pay area due of 2,76,558 only, including further interest as specified in certificate number so and so forwarded by authorized officer. Because in the last mile, you are hereby required to appear before the undersigned on 8 January 2014 at 11 a.m. and to show cause why you should not be committed to civil prison in execution of the state certificate, my lord. Got it, my lord.
Yes.
In next page, we have given reply to the said so-called notice, my lord. We have maintained that only 9%, only 9% are employed. No. Only 9% of employees since the date of establishment, my lord. Then they file a criminal petition before the Chief Judicial Magistrate, Guwahati, my lord. For failure to pay a contribution of rupees 2,01,998 rupees. Annexure 8, page 37, they filed a complaint petition for the Chief
Annexure,
Judicial Magistrate, my lord.
annexure,
Annexure 8, my lord, page 37. They filed a
Yes.
they filed a case before the
Complaint.
Chief Judicial Magistrate, Guwahati, Kamrup, my lord. For page 39, para 7, my lord, page 37, they have my lord, page 39, para 7, my lord. The accused person being the proprietor employee have failed to pay contribution of rupees 2,01,988 for a period from 1/9 to 7/12 within the stipulated time under the provision of VSI Act, so that they filed a petition before the CJM, my lord, Kamrup. My lord, in annexure 9, page 41, my lord. Employee State Insurance Corporation prepare a preliminary survey report, my lord.
Was done by whom?
It was done by preliminary survey report. Inspection Office, Employee State Insurance Corporation. It was signed by manager, my lord, in page 44, my lord. Signature manager, name of the inspector, branch manager, my lord. It was found that in the inspection report, my lord, page 45, my lord. Page 45, observation slip, my lord. In observation slip, we have employed 10%, my lord. Page 45, my lord. Last one is Mr. Subhash Das. In this regard,
He was a casual employee.
he was in this regard. I want to submit that, my lord. It was
Casual
as casual employee, my lord. In this regard, I would like to submit that. Subhash Das. Para 8 of my petition, my lord. Page 6, my lord. Para 8, my lord. While going through an associate complaint petition, your petitioner found that a complaint had enclosed along with the complaint petition a preliminary survey report dated 18/12/2008, along with the observation slip, wherein it was shown that there was 10 number of employees in the petitioner mill, my lord. Your petitioner got surprised to find in the observation slip that one Subhash Das was shown as casual worker at serial number 10. of the said observation slip, whereas no worker with the same name has ever worked in the mill of the petitioner. The said observation slip was shown to have been signed by the employer. In this context, where petitioner specifically states that he has never signed the said observation slip, nor any authorized person of the mill has signed the said observation slip. The official of ESIC immediately made the said observation slip by putting the names of 10 workers so as to implicate the petitioner with the offense alleged in the Eastern complaint petition. Subhash Das has not ever worked in our mill, my lord. He's just a casual. He never. He's not an employee of our mill, my lord. And the petitioner has never signed the observation slip, or nor any authorized person has signed the observation slip, my lord. Let me get it faster. The last submission is we do not fall under the purview of section 212 of the SI Act, my lord. That we have been employed only 9%, not 10%.
So your basic decision is that you never employ 10 or more than 10%?
No, we never employed
10 or more than 10%?
10%, we employed 9%.
9% and 10, Mr. Subhas Das, who was employed, he was barely a casual employee. So you do not.
He was not an employee of ours, my lord. And when the petitioner never signed in the observation slip, my lord.
Huh?
Petitioner never signed in the observation slip, my lord. But that is page 45. We have page 46, my lord. The sign is not with that of the petitioner, my lord. Not any authorized person has signed. Next. ওঠুনা রাখা হবে। ওঠুনা। And then the next item, my lord, the factor almost similar, my lord. In this, in the next case, my lord, Rahul Chandra Rice, email petition 699, my lord. The factor is almost similar, so I will directly jump.
Number 8, the petitioner, he was running the bill, and who is now number 9, item number 9?
Item number same.
Nothing.
Item number 9 is also a sawmill, my lord.
Oh, it's a different sawmill.
It's also a sawmill, my lord. The names are different, Miss Roy Sawmill, my lord. I mean Roy Sawmill. In this sawmill, my lord, page and annexure to page 16, my lord. Annexure to page 16, my lords. In maximum number of worker 9, my lord. In calendar year 2010, my lord. Next annexure, page 17. Page 17 for calendar year 2011-13. The maximum number of workers is 6, my lord.
So annexure 3, page 18 also similarly.
Same,
supposed to be-
all same. I just like to jump to annexure 5, page 25, my lord. Preliminary inspection survey report. Almost same, my lord. In page 29, my lord. The last one, monomer, page 29, observation slip, my lord. Serial number 10, Monomer Roy. She's shown as casual, my lord. But in the next, page 31, my lord, annexure 6, my lord. Voter ID, I card of Monomer Roy, my lord. He's the son of Rahal Roy, my lord, Rahal Chandra Roy. He's also page 32, my Monomer page 32, my lord. Monomer Roy, son of Rahal Chandra Roy. Rahal Chandra Roy is the owner of the mill, my lord. He's the petition hearing, my lord. Petition number 1. He's not a worker here. He's not a worker. Yes, he's the son of the owner, my lord. His name has been later on given by the insurance inspector, my lord. He's the son. He's 32. He's the son of the owner, my lord. Yes. Out of it. Number 10 to my lord, item number 10, my lord. All item number 10. This is also sawmill factory. My lord, page 14, annexure 2, my lord. Calendar year 6 months. In the calendar year 2008, 6 numbers of worker has been employed. page 14, calendar year 2008. Maximum number of worker on any one list, six number. Next, page 15, and next 2A, 2009, 9% employed. And next page 15, and next 2A. Page 16, page 16, and next 2B, in the calendar year 2010, 9%, maximum numbers of worker on one day, 9%, my lord. Almost all the same, my lord. I will directly jump to observation slip, my lord. All the facts are almost same, my lord. Identical.
Observation page.
Page observation slip at page 30, my lord. Raju Devnath, actually number 10, casual. In this regard, my submission is that, my lord. Para 7, page 5, my lord, in my submission, my lord. May I allow to read, my lord? That page 5, para 7, my lord. While going through a apposite complaint petition, your petitioner found that complaint has enclosed along with the complaint petition as preliminary survey report dated 18/12/2008, along with the observation slip, where it was shown that there was 10 number of employees in the petitioner mail. Your petitioner got surprised to find that in the observation slip, one Raju Devnath was shown as casual worker at seal number 10 of the said observation slip. Whereas no worker with the same name has ever worked in the mill of petitioner. In fact, Raju Devnath is the owner of Tata Magic delivery van bearing registration number so and so, who earns his livelihood by driving the said vehicle himself, and in connection with the said Raju Devnath used to come to the sawmill along with the vehicle for carrying timber and to and from sawmill, my lord. The said observation slip was signed by the manager of the mill, Sri Vishwajit De. However, when the said Vishwajit De signed the observation slip, at that point of time, there are only 9 names of worker in the observation slip. The name of serial number 10 worker was added later on by the insurance inspector, my lord. Well, in page 32, annexure 8, my lord. Annexure 8, page 32, my lord. The driving license of Mr. Raju Devnath, my lord. Name Raju Devnath, my lord. Vehicle type, my lord. Delivery van. Page annexure 8, page 32, my lord. The personal details of Raju Devnath, my lord. Vehicle types, delivery van. Vehicle class, delivery pickup goods carrier. Okay. Well, my last submission will be all these 3 matters. The petitioner never employed more than 10%, my lord. Therefore, does not fall under the purview of section 212 of the ECI Act, my lord. Number two, my lord, the petitioner is not liable to pay any contribution under ECI Act, my lord, because it doesn't fall under 212 out of factory. That's why. In all the three observation leave, my lord, all the three observations leave. The name of the person, my lord, was never an employee in the statement. That's it, my
Yes, Lord. Basically, the petitioners are here before your lordship, the section 482 for quashing of the complaint petition. That is the basic. And before I submit, my lord, I would like to place the definition of the statutes of the ESI. Your lordship may come to section 1(6) of the Act, my lord, at page 5. Or if I may read the preamble, my lord, the Act. Then Act to provide certain benefits to employee in case of sickness, maternity, and employment injury, and to make provision for certain other matters in relation thereto. Whereas it is explained to provide for certain benefits to employee in case of sickness, maternity, employment injury, and to make provisions for certain other matter in relation thereto. So it's a social legislation, my lord. And if your lordship may come to section 1(6), section 1 subclause 6 at page 5 of the Act. So lordship got it? My lord, here, my lord. A factory or an establishment to which this Act applies shall continue to be governed by this Act, notwithstanding that the number of persons employed therein at any time falls below the limit specified by or under this Act, or by the manufacturing processes therein ceases to be carried on with or aid of the power. So once once the factory or any establishment comes within the purview of the ESI Act, my lord, it is deemed to be governed, and it is deemed to be continued unless and until the factory has been closed by paying the relevant contribution, my lord. And here, my lord, the sole ground which the petitioners have approached is honorable court is the disputed question of facts whether there are 9 number of employees or more than 10 number of employees. In my all respect for submission, it is a matter to be decided by a trial court whether the disputed question of facts, whether there are 10 number. In our preliminary survey, which your lordship will find at page 41 of the. This is our preliminary survey report, and where we have found that there are 10 number of employees employed in this organization. And under this, so we have also approached, we have given enough show cause notice, paid the contribution, and this is only disputed question of facts. He's saying the only ground taken by the petitioner is that there are less than 10 number of employees, and the factory doesn't come within the establishment of the purview of the ESI. That is a disputed question of facts that has to be. And if at all, if the petitioner was aggrieved by the first show cause notice, he could have also approached the ESI court, at section 75. There is alternative remedy in case of any dispute regarding such disputes. The lordship may come to section 75 of the ESI Act, National Lordship got it. Matters to be decided by the employees insurance court. If any question or dispute arises as to whether any person is an employee within the meaning of this Act, or whether he is liable to pay the employees a contribution, or so many, if a lordship come to straight away come to clause G, or any matter which is in dispute between a principal employer and the corporation, or between a principal employer and an immediate employer, or between a person and a corporation, or between an employee and a principal or immediate employer, or so and so. All this disputed question of facts or matters may be decided by the employees insurance court. That is, the petitioner could have approached there, the employees insurance court. And the sole ground, again I'm repeating, the sole ground of coming before this honorable court is that there were less than 10 number of employees. And in my all humble submission, this is a matter of disputed question of facts, has to be decided by the trial court whether it comes within the purview of this section ESI Act or not, my lord. And rightly, they have signed the observation slip. Now he's disputing that he has not signed it. And in item number 9, my lord, Your Lordship, everyone has signed it. If Your Lordship will come to page 31,
In
the
item
petition 31, my lord. The observation says page 31 of the, if Your Lordship will come down, my lord. It has been duly signed by the, approved by the petitioner,
in item number?
my lord, 9. Well, in fact, in all the items, my lord, in all the observation slip, the signature has been duly signed by the petitioner that yes, there are 10 number of employees. And again, my lord, this is a disputed question of fact. And if Your Lordship may come to the definition of an employee within the meaning of the Act at section 9. Section 9 of the Act. Page 7 of the Act. As Your Lordship got. Section 9, man, the definition of employee. Employee means any person employed for wages or in connection with the work of a factory or establishment to which this act applies, and who is directly employed by the principal employer or any work of or incidental or preliminary or connected with the work of the factory or establishment, whether such work is done by the employee in the factory or establishment or elsewhere. Two, who is employed by or through an immediate employer on the premises of the factory or establishment or under the supervision of the principal employer or his agent on work which is ordinary part of the work of the factory or establishment or which is preliminary to the work carried on or incidental to the purpose of the factory or establishment. Three, whose services are temporarily lent or let in on hire to the principal employer by the persons with whom the persons whose services are so lent or let on hire has entered into a contract of service. So the definition of the employee is wide, my lord. Whoever works with a factory or the temporarily or comes within the definition of the employee. And if Your Lordship, I'd like to place one decision, my lord, this Honorable Supreme Court, where it has been time and again said, while exercising jurisdiction under Section 482 has to be exercised sparingly. Court has a prima facie satisfied that there is absolutely no jurisdiction or authority. Here is a case where there is a disputed question of facts, whether this is 9 or 10 has to be decided by a trial court in my all humble submission. And I would like to place the judgment, mother. Just 2023 4 SEC 338, mother. Here it is laid down, mother, the court while exercising jurisdiction under 482 has to be exercised sparingly. This is my humble submission. And even, Malad, one more last submission. The court, the chief judicial magistrates have not even taken cognizance of the matter. And then the petitioner have come at a very initial stage. Then no cognizance has been taken. It has come to their knowledge that the case has been filed and they have approached, matter. In their own statement, Malad, if Your Lordship may come to paragraph 7, page 6 of the petition. They have said that, and there's been no cognizance have been taken yet by the Honorable Court below. So in my humble submission, this is a very premature petition that has come for Your Lordship, and it involves disputed question of facts, which has to be determined by the trial court whether there are 9 or 10 employees. That is my.
No, nothing is submitted, madam.
The case is, cognizance is yet to be taken, not
Yet to be taken.
I checked in the record earlier. Some orders has passed, madam. In the record.
Order has passed means?
Some orders in earlier, not today. I have checked some orders are passed in the trial court record, madam.
They have approached their not it is not been ended. But even if cognizance has been taken, even then also, my lord, my submission will be that it will be very early stage to determine
No,
whether
he
they're
is saying from your petition that at the time of
No,
filing
no,
your
for
petition.
mine, not my petition. I've checked in the records earlier.
No, 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 no.
from their petition.
From your petition, he is saying that at the time of filing your petition, the cognizance was not taken by the court.
It has come to their knowledge, at paragraph 7, my lord. Came to know about the filing of the complaint. Paragraph 7, my lord, at page 6 of the petition. Again, my
Now, have you received any notice, summon or whatever from the court? Not yet.
Not yet, my lord.
not yet, they have not done it. In their own statement, they have stated that it has come to their knowledge about the filing of the their approach. And again, my lord, it's a very premature, my lord, to determine whether there are 9
No,
employees.
now he is saying that, I don't know whether cognizance in the, I mean, the PCR you have seen.
I have seen some orders passed, that's why. It's not in our petition, my lord.
We'll check them.
Check that.
Let me check.
Just time for 5 minutes
I
and
think
then
I'll-
just check
I'll
the
check.
records. Whether there was any stay, no.
There was a stay.
Stay, my lord.
Then obviously that should not.
Question of fact whether there are 9.
After cognizance, have you received any notice or summon?
We have already, we have appeared in that case.
You have already appeared.
Appeared.
And then there was a stay by this honorable court, my lord.
Acha.
That
Now, presently the stay is
stay is
operating.
still
Stay operating, my lord.
My submission would be same, my lord. It's in both disputed question of fact, whether there were 9 employees or more than 10 employees. Our survey indicates otherwise. They are saying
And
otherwise.
apart from that, as per you, in the observation slip also they put their
They
signature.
put their signature. Again, they are denying that is a matter subject to be decided by trial court. That's my submission. And I place a judgment, my lord, where your lordship is aware of that. If this court, while exercising the jurisdiction, the court has to be exercised sparingly. In all the cases, 3 cases, my lord, they have put their signatures in the observation slip. Come,
Okay.
Ma-
Okay. Here, the respondent number on behalf of respondent number 2, there are 1, 2, 3, 4,
My lord, here,
5 names are
my
there.
lord, here, respondent number 2 was the cooperative society, my lord, register of cooperative society. Perhaps the Dr. B. Ahmed was standing counsel at that time, my lord, cooperative society.
Oh, acha.
And
Now, what
rega-
about Mr. N. Hawker, then
there
MBK?
others,
Then there are others names. Anyway, the petitioner is also absent.
my lord, prisoner.
And appears on call for
Lordship, may kindly please occasional, my lord, 30/10/2025, my lord.
3010.
My lord, 30.
Oh, it has not been received.
Only the appellate court record is available. That is also.
Why it is happening? Same question. I mean, appellate court's
My lord.
record is there. Where
My-
is the other?
No.
None appears on call for the petitioner. Mr. B. Sharma, Dilani, then PP. And no, not here the response number 2. So names of 4 councils have been reflected in the part rate is submitted by Mr. Shah. That as for the office note, it's in that the case record of GR 79 of 1996 has not yet been received by the registry in spite of sending requisition. In view of this, the reference requisition is sent to the court of Planet SDGM Bongaigaon to send the case record of GR 1996. It will be required for the purpose for the for the hearing. Let the matter be accordingly listed as on a date to be by the registry or immediately after receipt of the case.
May it please your lordship. No, here is a case for quashing, my lord. This is with regard to, my lord, a complaint case that was preferred in the lower court below, wherein, my lord, if your lordships come to my quashing petition and annexure with regard to the complaint, that is 4285 of 2013. Now, the accused persons, my lord, will kindly see number 1, Brahmaputra Teleproductions. Number 2, the managing director, Brahmaputra Teleproductions. 3, DY365, the brand name is also been made and accused. Pronoy Bordole, accused number 5, editor. Navajit Borthakur, Sinta Sikha, 7, Santi Saya Das. And these are the accused persons, my lord. This quashing petition is so far with regard to only the managing director. She is before the court. And if your lordships comes to the order, first order, wherein this honorable court was pleased to stay the proceeding. Yes. Order dated 11/5/2015, my lord. This is with regard to only so far it relates to the present petitioner is concerned. Now, if this honor, my case is very simple, my lord. So far, my lord, media is concerned, Press and Registration Act is applicable. So far, electronic media is concerned, there is no law as such, but the principle governing it is the Press and Registration Act itself. Now, in the Press and Registration Act, there are provisions wherein process can be issued. There can be an owner of a newspaper. There can be a managing director or a chairperson of a newspaper if it's a company. And there has to be an editor, and there has to be a printer and publisher. And in the bottom of the particular newspaper, every newspaper, my lord, there's been a column declaring that who is the editor, who is the printer publisher. That is the sine qua non, the mandatory provision. As per the Registration Act, if there is an executive editor, no cognizance can be taken. That's the law. Only the law presumes with regard to editor and printer publisher. So far, with regard to electronic media is concerned, that is the editor person. Here, no question of printer and publisher is concerned. So here is a case wherein, my lord will kindly come to page 8 of my complaint, wherein the name of the petitioner is not been mentioned. Also. Page 8 of my quashing petition, my lord. Yes.
Yes.
She is an employee, my lord. What is the allegation that has been stated in paragraph 6 is concerned, my lord. 5 and 6, my lord. Accused number 1 represented by its managing director. So now, in a case of company, my lord very well knows that in a juristic person, my lord, where a juristic person is an accused, any person by way of, my lord, resolution can appoint to represent the company is concerned. So here, the accused, it's the complainant herself makes the managing director to be an accused. Am I clear? That cannot be here. That is my first ground with regard to this. What has been stated is very important. represented by its managing director, and the complainant decide who will be representing the company. Accused number 2 is the private company engaged in the business of distribution, dissemination of news, etc. through its electronic news channel, commonly known as DY365, which is the accused number 3 in the instant case. The accused number 4 is the editor of the said news channel. So editor is also an accused in this case. And there is no quashing petition been pending and preferred by the accused. Number 3, editor. Editor of the news channel, and the accused number 5, 6 are news readers who has read the offending news item broadcasting the same on the dates on the offense as stated above. The accused number 7 is the person who had made rampant false, derogatory, defamatory, and brought incorrect and false allegation against the complainant through the medium of the accused number 1, 2, 3, 4, and 5. So what I am on, that this was a program in the new channel wherein participant has various person has taken participated in the show. It was a live show wherein some of the persons make allegation with regard to that, and it's a live show, it will go, and this is in public interest again. Now my lord will kindly see there is absolutely no allegation so far managing director is concerned, because managing director is running the company not with regard to what is been broadcasted in a news channel, my lord, what is in a press, my lord. The editor, what is the role of an editor, my lord? That's been defined here in the Press and Registration Act. And I am reading it, my lord, that what is the role of the editor? Yes, it's been defined here itself, my lord, that for Press and Registration Act, Khondiba, 1867. Here the definitions, my lord, I am reading it, my lord. Editor means the person who controls the selection of the matter that is published in the newspaper. Am I clear? I'm giving my book, my lord. So editor is the person who is responsible for selecting of the news. There can be 100 news. So what will be printed in a newspaper, that is the role of the editor. So for printer and publisher is concerned, 7 of the Press and Registration Act 1867, presumption is against editor, printer, publisher, no other person. Even the managing editor cannot be roped in. Even the executive editor cannot be roped in. That's the law of the land. Now here, a news article that has been there, my lord, wherein some persons, my lord, with regard to, is the person made the accused number 7, made some statement against this. It is stated that the managing director, accused number 2 of the said news channel, takes a keen interest in the selection and publication of news which are aired in the channel, apart from selling the said news item for which accused person is liable to be punished under 500(2). These are omnibus statements, because the role of the editor has been given go by. Editor has been by a statutory law, editor role has been defined. It is mandatory that editor name has to be published in the newspaper. So far electronic media is concerned, there is no printer publisher. This is the live telecast, satellite linking, and live telecast. Cable TV regulations comes into, my lord, and that's only a guidelines, nothing else, wherein it is only the editor who is responsible. Now, editor is not before the court, and whatever news article is been there, and for that purpose, the person aggrieved, the complainant filed this complaint, and initial deposition was recorded, and thereafter process issued. I being aggrieved by the issuance of process is before this honorable court. And my ground is this, that you cannot rope in the managing editor or the chairperson of a company, that too in an electronic case. And with regard to that, my lord, I am placing my reliance to the there is a coordinated judgment, my lord, on same, my lord, same DY 365 case, my lord. Did you copy it? Criminal petition 33 of 2015. Yes. May I come to paragraph 6, my lord? Paragraph 6, my lord. Challenging the aforesaid proceeding, including the order of taking cognizance, the petitioner is before this praying for quashing the entire proceeding on the ground that the learned trial court has erred in law while taking cognizance against the petitioner, as she being the managing director of the company has nothing to do with the programs broadcast by the new channel. It is the contention of the petitioner for the purpose of broadcasting program. Editor-in-chief is solely responsible and is not responsible for selection news items for the purpose of broadcasting, and nothing such is also averted in the complaint petition. It is submitted that the managing director of the company cannot be first-end with criminal liability and no vicarious liability can be attributed towards the petitioner. It is always the editor who is responsible and have control of selection of matters for broadcasting, inasmuch as cognizance taken against the present petitioner is bad in law. 7. Learned counsel so-and-so argued before this honorable the petitioner has been wrongly arraigned as an accused in the aforesaid case who have no role in broadcasting the news, and concept of vicarious liability is foreign to the criminal law. It has also been contended that except some vague allegation so far as regard to the present petitioner, the complaint failed to reflect about the participant of the petitioner as the managing director towards the publication of the defamatory news item, and she has active knowledge thereof. Paragraph A. This is again my lord, Andhra Pradesh judgment relied by me, my lord, wherein it has been held that only telecasting a news by a TV channel have no way bearing in deciding the complicity of the managing director in gathering the news item. Selection the news item for broadcasting the criminal liability of defamation cannot be first-hand, and the managing director at the helm of affairs in the television have no vicarious liability on criminal side can be attributed unless there is specific or special provision under 490 and so him with vicarious liability. Ultimately, my lord, it has been quashed on this ground. Only on same grounds, my lord, paragraph 14, there are judgments with regard to this. Supreme Court judgment is with regard to print, my lord. Press and Registration Act, my lord, so far newspaper is concerned. And ultimately, my lord, it was quashed. Lot of judgment has been, this is the law with regard to this. And under judgment, I am relying it, my lord. Yes, I'll coordinate bench of this Honorable High Court. Criminal petition 556. This is with regard to some of the functionaries of a company, my lord. 2012. My lord, 556 of 2012 is 13, my lord. This is with regard to vigorous liability, my lord, whereas jurisdiction is exercised by a complaint petition filed in terms of 156 or section 200 of the Code of Criminal Procedure. The magistrate is required to apply his mind in Indian Penal Code does not contain any provision attaching vicarious liability on the part of the managing director or the director of the company when the accused is the company. The learned magistrate failed to pose unto himself the correct question as to whether the complaint petition, even in taken in phase and taken to be correct in its entirety, would lead to conclusion that the respondent herein were personally liable for any offense. The bank is a body corporate. Vicarious liability of the managing director and director would arise provided any provision exists in that behalf in the statute. Statutes indisputably must contain provision fixing such vicarious liability. Even for the said purpose, it is obligatory on the part of the complainant to make requisite allegation which would attract the provision of vicarious liability. So absence with regard to statutory provisions with regard to vicarious liability, it cannot come into. And again, paragraph 19 is very important, my lord. Going by the projections made in the complaint and the expression provided for the aforesaid statutes, the alleged defamatory news item or its transcript would fall within the category of documentary evidence, more particularly with the expression electronic record. So, my lord will kindly see that so far Indian Evidence Act is concerned, it has been subjected to, my lord, amendment. So, previously electronic record is not part of the definition. 1710-2003, my lord, the definition under Section 3 of Evidence Act, document definition has been amended. So electronic record has been incorporated. Apart from that, my lord, 65A, 65B has been incorporated. 65A primary, 65B secondary evidence, how it is to be dealt with. Apart from that, 22A is also been there. 22 was this of the Evidence Act that oral testimony as to a content of a document is irrelevant unless and until at least secondary evidence is tendered. After introduction with regard to 710 on 2003, 22A was introduced, my lord, wherein it says oral testimony as to electronic record is inadmissible, irrelevant, unless and until secondary evidence is given. So why I'm on that this paragraph says in volume that with regard to taking cognizance of the offense, my lord will kindly come to the petition itself and the order of taking cognizance once. That appears in page number 21. These are on the basis of statement made by witnesses, my lord. At page 20, order of taking cognizance, my lord. Now, kindly see how cryptic order is. Allowed upon consideration, peruse the complaint witness, the statement of other witness record, and therefore I find prima facie sound. The material on the basis of which the roots is the very telecast was not before the court. And on the basis of oral testimony with regard to an electronic record, on the basis of which cognizance has been taken, which is absurd and which has been discussed in paragraph 19 of this particular judgment, my lord. That it sums up, my lord. Paragraph 19, if your lordship appreciates it, my lord. The criminal prosecution has been launched against the accused person on the premise that the alleged news were broadcast through the television DY is defamatory in nature. During the course of inquiry, the said alleged defamatory news item, which for the complainant is the foundation for launching the criminal prosecution, has not been produced before the court for its examination. It is not even mentioned in the statement of the complainant, and the said item would be produced at a subsequent point of time. Nothing has been said by the complainant that he had made any effort to obtain alleged defamatory items from the rightful source and had failed this attempt. Thus, the alleged defamatory news item not before the learned trial court at the time of taking cognizance of the offense and issuance of profits against the accused to arrive a prima facie opinion, the same is defamatory in nature. Am I clear, my lord?
But from the order of the cognizance,
Yeah.
how can you say that this news item and those?
No, what are the materials that was placed and on the basis of which cognizance has been taken? The materials are the complaint petition, the statement of witnesses that I have annexed, my lord, can you see? Therefore, I prima facie found sufficient. What is the statement? Complaint petition, statement of complaint, the statement of other witness record under 200. This is the material. And my lord, I have annexed the statements also, my lord, 161, my lord, will kindly see. 161, at least 22, my lord. That is the complainant's statement, my lord. Nothing. And page 23, my lord. That is another witness. Page 24, another witness. Page 25, my lord, another witness. That's all. And all the vernacular statement is also I have annexed, my lord. So what I am on, there cannot be a tree without the roots. The very basis with regard to that was not before the court at the time of taking cognizance. So the cognizance order is bad in law. That is been reflected in paragraph 19, my lord. That is the basics, my lord. Suppose I go for filing a forgery case, my lord. Now, in forgery 464 definition, there are two parts. One is forgery, one is a false document. I signed today a document made by me, Anand Kumar Bhuiyan, Prime Minister of India. That is not a forged document. That is a false document because I am not the Prime Minister of India. But if I make a document, Prime Minister of India, Narendra Modi have signed in, put a seal, that becomes a forged document. That's the distinction between the two. For launching a criminal prosecution with regard to that, there has to be that forged or false document. Even if it is not there, where is the prosecution? Am I clear, madam? And apart from that, the law with regard to this, electronic medias and all, there is no law. The spirit of Press and Registration Act is followed, wherein for the first time in 1867, the role prescribed of the editor has been defined, and printer and publisher has been defined. And the presumption is also there with regard to this. So, my lord, another Supreme Court judgment I am placing it, my lord. Kerala High Court, my lord. 21. Party naam to পার্টির নামটা কোথায়? হ্যাঁ, জোসেফ Uzilkil Jalil Aru FR Bobby Alex. Paragraph 21, my lord, I take your lordship. My lord, everything has been discussed here, my lord. And that's been the law altogether. 24. Applying the ratio, it could be held that it is the editor, chief editor or the editor who is the ordinary course is responsible for selecting news item and the managing director is no direct role in selecting news. Therefore, the criminal proceeding alleged defamation against the managing director would not succeed prima facie. Am I clear, my lord?
Which paragraph?
Paragraph 21, my lord. Everything has been discussed, my lord. Mere vague statement will not do, my lord. This was against, my lord, my lord, the managing director, for which it went to the High Court. Ultimately, it was quashed. So this is my sum and substance with regard to my argument, my lord. That no prima facie case against the man. Other person is concerned. I do not know at this stage, my lord. 2015, it was been filed. The complaint happens to be of 2000, my lord. Whether that complaint, petition, that trial with regard to the other accused is going on, necessary order. It has been pending, but for necessary orders for the other accused persons. That's my sum and substance, my lord. Law is very clear that managing director cannot be roped in, my lord.
May I please, your lordship? My lord, first and foremost, my submission here would be whether, my lord, in exercise of powers under section 482 of the CRPC, my lord, the parameters what is to be seen by this court has been circumscribed. It is, my lord, whether, my lord, on a bare reading of the complaint or the FIR, my lord, some allegations against the, my lord, accused persons are made out or not. That is the first and foremost, my lord, parameter within which, my lord, this court will circumscribe its powers while exercising authority under section 482 to quash. The question is, my lord, what is to be read is to the complaint that is to be read as a whole. And your lordship is aware, my lord, when it is a company which is sought to be, my lord, made a party in the proceedings, the company is a juristic person, my lord. It has got no hands and feet of its own. It is run by somebody who has got a head and who has got hands and feet. Now that person is the managing director or the director or whatever, man. We have stated in the complaint, if your lordship kindly comes to paragraph 7, my lord, of the complaint, that your lordship finds at page 12, my lord. It is stated here that the managing director, accused number 2 of the said news channel, takes a keen interest in the selection and publication of the news which are aired in his channel. Apart from selling the said news items for which the accused person is liable for punishment under section 12. So, my lord, at this point of time, an allegation has been made that this is the person who is also responsible for selection of the news and what is to be aired or what is not to be aired. That is there. Thereafter, your lordship will kindly come to paragraph 14 at page 16, my lord. That is paragraph 14 of the complaint.
Paragraph 14 of the complaint.
14 of the complaint, my lord, at page 16 of this, my lord, criminal petition. May I read out, my lord?
Yes.
Paragraph 14, the complainant states that the said news items were aired with a view to show that the complainant is corrupt and promotes corruption through her association with the members of the APSC and also misuses her authority in the said APSC for illegal purpose. which is totally false, baseless, and defamatory. By the said news imputation, a CD of which is attached herewith and shall form an integral and inseparable part of the complaint to be read together with the complaint. So it is not a case where we have not given the documentary evidence of what was aired, my lord, and by which we became aggrieved, my lord. That was very much there with the record, and it has been taken, my lord, by the court below, my lord. The accused persons named above, have conveyed the meaning that the complainant is a corrupt person who has misused her position for her own selfish interest and has negotiated with for undeserving candidates to be included into merit list in exchange of money, which is totally false, baseless, and defamatory. Then I have stated, my lord, how they have done it. Then if your lordship comes to paragraph number 18, at page 18, my lord, that it is stated that the accused person number 1, 2, 3, 4, 5, 6, and 7, after a prior meeting of mind and in furtherance of the common intention, broadcasted the two aforementioned news items with intention, knowledge, and having reason to believe that they by their act would seriously harm the reputation, prestige, social standing of the complainant, and therefore these accused persons are to be fastened with penal liability. So it is not a case where no allegations have been made against the accused persons, my lord. Now, my lord, while coming to the judgments of Bhajanlal and thereafter Niharika, my lord, today, which holds the field as regards, my lord, the exercise of powers under section 482. What Bhajanlal and Niharika have laid down is only the complaint or the FIR that is to be seen, my lord. Not, my lord, what evidence has been recorded, my lord, while taking cognizance of the case. Because, my lord, if, my lord, what evidence has been recorded while taking cognizance of the case is to be seen. Because this is a case, my lord, which is under the warrant procedure. So, my lord, after explanation of the offences against them, my lord, they will have the chance to rebut, my lord, whatever has been stated, whether the managing director is really involved in the dissemination of the news or not, my lord. My lord, to come at this stage before this court and say, my lord, that the managing director is not, my lord, included or is not involved in the dissemination of news is, my lord, on the merits of the case, which is to be seen only by the trial court, my lord. And the fact that, my lord, the question of vicarious liability, as has been stated, my lord, there is no question of vicarious liability in this case, my lord. We have not stated that even though by dint of his position as a managing director, he is to be included. We have not said that, my lord. Had we said that because he represents the company and the company was at fault somewhere, my lord, that is why by the applying the principles of vicarious liability, he will be liable. We have not stated that. If your lordship again sees, my lord, that paragraph 7 and 14 and 18 of this petition, my lord, lordship will see that, my lord, direct, my lord, allegations are made against him. So the concept of there being any vicarious liability in a criminal proceeding, it does not arise because we are aware of the fact, my lord, that in a criminal proceeding there cannot be vicarious liability. Because, my lord, the principle of vicarious liability has been understood even in the concept of this Motor Vehicles Act cases, my lord, where that driver, my lord, who commits the offences, he commits the offences that he is liable for that, my lord, because he belongs to the employment of somebody else who is the owner of the vehicle, he cannot be dragged into. Of course, until and unless to the, my lord, restrictions of having a particular insurance policy or whatever, my lord. That is the concept, my lord. So here also, my lord, it is not that we have, my lord, named the company, and because, my lord, the person is the managing director of the company, that is why we have come to say that he is vicariously liable. We have not said that. Allegations are directly against him. Allegations are there, my lord. So when allegations are there, these questions will not come into play, my lord. As regards the Press and Registration of Books Act, my lord, that basically relates to, my lord, anything published in the newspapers, my lord. And that, my lord, by that, the press and registrations of books act, my lord, what is required is, for a time to time, a statement is to be given by the owner of the newspaper or the publication house to the government saying that so and so, so and so, so and so person are responsible for the purpose of dissemination, editing, selecting, and publication of the news, my lord, which appears in the bottom line at the last page of each newspaper, my lord. There, my lord, now a paper in newspaper for the purpose of, my lord, its own business, my lord, or for the purpose of, my lord, getting some ease of doing business may appoint somebody in the position as an executive editor or somebody, my lord. Now, there was a case of Justice Horace Borough's judgment is here, my lord, of this court today. Actually, what happened today, my lord, I had lost track of the file and I did not have the file also with me. I collected a copy from him in the morning here, my lord, and on that basis I am submitting. I did not have any idea, my lord. Now, whatever, so that Justice Horace Borough's judgment also says, my lord, lays down that particular fact that when it is only those persons who are named in the registration of press and registration of books act, my lord, then those are the persons who can be held responsible, my lord, not any other person by any other name. But here this is not a case because in principle the press and registration of books act might apply, my lord. Applying principally and applying in toto is a different concept altogether. And basically when this is an allegation, my lord, which is made, where a direct, my lord, allegation has been made, my lord, and my lord, that copy of the CD has also been given on record, my lord, under 65B of the, my lord, Evidence Act. My lord, that is already there, my lord, I have stated, my lord. So, my lord, there is, on the basis of the complaints which has been made, there is nothing wrong, my lord, in the cognizance which has been taken, my lord. And as the petition itself, my lord, discloses allegations, my lord, against the, my lord, this petitioner who is before your lordships, my lord. So, my lord, this complaint is to stand and the complainant, this petitioner has to, my lord, face the trial, man. This is my humble submission. Because the area of the court on which the court will see has been circumscribed. Niharika and Bhajan Lal, my lord. Thereafter, there are so many else, but because Niharika is ultimately 3 judges bench, my lord, bench which is holding the field, my lord. So Niharika also says, my lord, that it is only the empire or the complaint, nothing beyond that, my lord. What has been now, my lord, stated in other cases is that, my lord, earlier it was that any of, my lord, documents which were submitted by the defense could not have been looked into, my lord, while deciding a petition under 482. But one, there was a slight dilution, my lord. It says, my lord, even the defense, my lord, produces certain documents which are, my lord, of sterling quality, are unimpeachable in character, my lord. Then, my lord, even that can be looked into for the purpose of coming, my lord. Good. But basically, my lord, what is to be seen is whether the complaint discloses, my lord, offences against the accused person or not. If it discloses, then it will go. That is by respectful submission, my lord.
I will
And
reply.
these, my lord, judgments which have been cited, my lord, these, my lord, judgments, my lord, do not, my lord, relate in any manner to the fact, because in the earlier cases also, my lord, as your lordship has, my lord, seen while my brother was, my lord, reading out, perhaps in those cases, my lord, direct allegation against the, my lord, managing director or whatever was not there. So, my lord, they were sought to be roped into by way of vicarious liability, which is not the case here. And because it is different, my lord, so, my lord, those judgments will not apply in the matrix of this case, my lord. This is my humble submission.
Yeah, I'll reply to this, my lord. My lord, it would be a dangerous proposition with regard to initiation of a criminal proceeding against any person, even knowing his name. Am I clear, my lord? If a statement made in a complaint that Tom, Dick, and Harry are the directors of the company without knowing who is Tom, Dick, and Harry, this is the case. My lord, will kindly see the complaint. Brahmutra Teleproduction, duly registered, so and so, so and so. Managing director doesn't know the name. Who is the managing director? She came in before this honorable court for quashing that I'm the managing director. Process has been issued in violation of the law. Now, so far with regard to my learned colleague's submission, taking to paragraph 7, whole of the news article, why the defamatory case has been filed, is been mentioned in paragraph 6. That the accused person number 7 is the person who made rampant, false, derogatory, defamatory, and brought incorrect and false allegations against the complainant through the medium of accused number 1, 2, 3, 4, and 5, who had broadcasted the said false news item without verifying the correctness of the same in a most reckless, responsible manner with utter disrespect to the law. So, a person concerned who is accused number 7, who makes a remark in a open TV debates with regard to certain persons. Thank God, my lord, the night watchman or the carpenter or the electrician in the company has not been roped in. And my lord, my learned friend is relying on paragraph 7. What are these statements? It is stated here in the managing director accused number 2, doesn't name the person, said news takes a keen and interest in the selection and publication of the news. So mean thereby, my lord, even my lord, editor is not responsible. Wherein statutorily, who are responsible with regard to print media and electronic media has been defined. My lord, Press and Registration Act, my lord, section 7. In any legal proceeding with whatever as well as civil as criminal, the production of a copy of such declaration as is aforesaid attested by the seal of some court empowered by this act to have custody of such declaration, or in the case of the editor, a copy of the newspaper containing his name printed on it as that of the editor, shall be held unless the contrary to be proved to be sufficient evidence as against the person whose name shall be subscribed to such declaration or printed on such newspaper as the case may be, that the said person was printer and publisher or printer and publisher according to the words of the said declaration may be of every portion of every newspaper whereof the title shall correspond with the title of the newspaper mentioned in the declaration or the editor. These are sum and substance against which, my lord, process has been issued. Now, Protein paper is one of the leading newspaper in Assam. Editor is something else. The owner, Jayanta Borua, he is the executive director. Now, anybody files it, he comes in and quash it because you cannot prosecute him. It's a law wherein editor, printer, publisher will come into. So, any nomenclature with regard to executive editor, chief editor, or any other any nomenclature will not help because you cannot file it. Even the owner, you cannot file it. Mayor making a statement will not do, my lord. That's what it in the judgment I placed it before the honorable court. There were vague statement, paragraph 13, kindly see, my lord. That will not help him, my lord, by any stretch of interpretation. Criminal 556 of 2012. Similar type of statement, my lord, to rope in the accused person. Paragraph 13, my lord, is the vicarious liability, and paragraph 19, my lord, wherein it has been stated, my lord, with regard to the documentary evidence, my lord. Assuming, my lord, they have produced some documents, my lord, with regard to this and all, because the complaint I have not just now I have seen it, my lord, in the body of the completion, last there appears to be 3 CD showing the false news broadcasting. They have given the CD. Am I clear, my lord? But the order of taking cognizance doesn't reflect it. Order of taking cognizance has been taken on the basis of the complaint petition, the initial deposition of the complainant and the witnesses. So nowhere it says so. Arbiter judgment ruling by the another judgment I have submitted, my lord. Paragraph 6 of the, my lord, criminal petition 33 of 2015, my lord. Paragraph again 6, my lord. You cannot fasten with regard to criminal law, making statements.
Criminal petition?
My lord, Rumi Baido judgment, my lord, criminal petition 33 of 2015. Yes. Yes. Paragraph 6, my lord.
Yeah.
Washington proceeding on the guardian taking cognizance as she being the manager, nothing to do with the program broadcast so and so. It is the contention of petition for the purpose of broadcasting so and so. Solely respondent, he is not responsible for selection of the newspaper for the purpose and nothing such is also averted in the complaint. It is submitted the managing director of company cannot be first degree criminal and no vicarious liability can be attributed towards the petition. It is always the editor who is responsible. Now, paragraph 7, my lord will kindly see. Counsel so has always argued that the petitioner has been wrongly arraigned as accused in the aforesaid who have no role in broadcasting and concept of vicary is foreign to the criminal law. It is also considered except some vague allegations. Am I clear, my lord? This kind of statement. Without even knowing the person's name, who is the managing director. So, my lord, now, my lord, Reliance Zio. There is no concept of vicarious liability so far this. You cannot rope in that he is looking after Ambani. Galaxy of Supreme Court lawyer will be here and arguing. No, this is long. Making a statement will not do. Otherwise, it will be, my lord, a dangerous proposition under law. That this person, although he is not the managing director, he will be roped in as a managing director, process has been issued. This cannot be by way of a statement, my lord, wherein statute specifically states with regard to the role of an editor for selection of the news article for the purpose of publication. In case of electronic media, selection of the news article for the purpose of broadcasting. And that was this new live program, my lord, wherein she have a case for which, for the other accused editor is been facing the trial. And for the editor, my lord, whatever happens, the trial court will decide. But you cannot rope in the managing director or the electrician or the generator person. You cannot. That cannot be allowed, my lord. That's the sum and substance, my lord.
My lord, I'll just put one line, my lord. First and foremost, as your lordship has seen, my lord, and he has pointed out, to make somebody an accused in a criminal case in respect to a newspaper, my lord, it is because the editor, publisher, and printer, because, my lord, they are required by the government to submit a list of all those who are responsible, my lord. It is only on the basis of that. This is a case of the electronic media, my lord, which is not covered there, my lord.
It's covered.
He cannot show, my lord. He cannot show that there is any
My-
requirement at any point of time by which the, my lord, editor, publisher, or, my lord, this broadcaster, they are named and their lists have been given, my lord, to the government, and that is why they are only to be blamed. It is not there at all. He says and submits before this court, it is only the spirit, my lord. Spirit is what, my lord? The spirit of the Press and Registration of Books Act is that, my lord, that you cannot, my lord, victimize somebody without, my lord, making an inquiry as to whether that allegation which has been made or that imputation which has been made is correct or not, my lord. So just because he says that it was a talk show going on and somebody, my lord, they were not bound to, my lord, disclose it, my lord. Because what they have done, my lord, kindly see, my lord. It is not so easy, my lord. Kindly see in the petition, my lord. In paragraph 12, the said news bulletin was broadcast as a sensational news with the headings as follows. On 29/11/2013, APSC সংগঠিত ভয়ঙ্কর কেলেঙ্কারি, meaning that some fearsome corruptions are going on inside the APSC where the name of the complainant was also highlighted so that it does not escape public attention. On 30/11/2013, APSC সংগঠিত ভয়ঙ্কর কেলেঙ্কারির দ্বিতীয় অধ্যায়, meaning it is the second part of the same fearsome corruptions are going on inside the APSC. On that day, the said news item as broadcasted by the accused persons reflected the name of the complainant, thereby mean that in respect to whatever allegations were made about the corruptions inside the APSC, the complainant was the main perpetrator of the same, which is utterly false, defamatory, and baseless. On 1/12/2013, অধ্যক্ষায় জনালে তদন্তৰ কথা, meaning thereby the chairman has informed about an inquiry into the allegations that were leveled by the accused number 7 and also showed the name of the complainant, thereby reflecting a meaning by which it was made to understand that there was an inquiry against the complainant, which is also false and baseless. The manner in which the said news item was doctored, morphed, prepared, and broadcasted, it enabled the false allegations appear to be true, which in actuality was not, and the manner of presentation made it certain that the name of the complainant does not escape public attention and that she could not escape defamation in front of the public and its viewers. So in this way, my lord, again, my lord, if your lordship turns over to the next page, my lord, on 3/11/2023, the second paragraph of page 15, my lord. The said accused persons number 1 to 5 again broadcasted another news with the heading APSC Kelenkariye Kopaise Rajya, Bitorkito Hodasyor Rahasyojonok Sthiti, meaning thereby that the corruptions inside the APSS second state vis-a-vis the Mercedes stand of the infamous member by which news item as so and so, so and so, so and so, and it is the accused persons targeted the complaint by showing her photograph in the said news broadcast. They had broadcasted the news, but it was not a talk show. They have broadcasted the news, and thereafter, during the course of the broadcasting and telecasting of the news, they have shown my picture, my lord, thereby drawing, my lord, the entire public attention towards me as if I was the perpetrator, my lord, of the entire, my lord, whatever, my lord, was going on within the, my lord, APSC. My lord. That is how I am before, and I have already stated 1 to 5. Here also I have stated, my lord, that in accused persons number 1 to 5 again broadcast another news. Now maybe I do not know the name of the managing director. Can that be, my lord, argument by which, my lord, my complaint will stand vitiated, my lord? Well, I put that question to myself and I say, my lord, it cannot be, my lord. I may not know the name of the managing director of the company, my lord. And, my lord, from the materials on record, what is required for the purpose of, my lord, cognizance, my lord? That, my lord, the learned magistrate, my lord, who has taken cognizance, has put his mind to whatever is there before him and has understood the case, and thereafter he has taken cognizance. This is all that is to be, my lord, reflected in the order sheet, my lord. And that has been very well been reflected, my lord. And, my lord, the complaint shows, my lord, as has been stated by him now, that, my lord, the CD of this entire thing was given to him. Therefore, my lord, it was not a vehicle, because in that criminal petition number 33, which has been pointed out by my learned brother, my lord, in that, my lord, what was the, my lord, finding of the court? That, my lord, no allegations was made against the managing director. Because no allegations are made against the managing director, my lord, by way of vicarious liability, he could not have been, my lord, robbed in. But here, my lord, there are direct allegations against the managing director, my lord. Because there are direct allegations against the managing director, my lord, and the, my lord, area of this court, my lord, to exercise powers under 482 is circumscribed, my lord, by these judgments, my lord, Niharika and my lord, Eric. So what does Niharika say? I'll just point out, my lord, one line, my lord. Power of quashing should be exercised sparingly with circumspection. While examining an FIR/complaint, quashing of which is sought, court cannot embark upon an inquiry as to the reliability or genuineness or otherwise of allegations made in FIR/complaint. That is Niharika, my lord. This is akin to the power, my lord, when a civil court exercise power under Order 7, Rule 11 of the CPC, my lord. Then whatever is stated in the plaint is to be stated, taken to be correct, my lord. Whatever may be the written statement, whatever may be the counter anywhere else, my lord, that is not for the consideration of the court. Just like in this case, while exercising powers under 482, my lord, whatever is stated in the petition on the complaint or the FIR has to be considered to be correct. Whatever may be the, my lord, answer of the accused person, my lord. Whatever may be the defense of the accused persons, my lord. So if it is to be taken as correct, my lord, and taken to be a demurrer as to whether, my lord, now a reading of this, my lord, complaint as a whole, my lord, makes out a case against the FIR, whether it contains allegations, my lord. If it contains allegations, then this, my lord, complaint will, my lord, it will stand, my lord, it will continue, my lord. If it does not, only then, my lord, power will be exercised. This is my humble comment.
My lord, it will be a never-ending process
No,
like
no,
this.
it's-
My lord,
Yeah,
that's
if you
too,
go on-
he raised a new thing, my lord, with
No,
regard to
no,
the law.
No, my lord.
Only
not a
law,
new
my
thing.
lord, is the cable TV regulation of 1994. And that, my lord, talks about the program code and the advertisement code. And it has been specific, my lord, what program can be telecasted, what not to be telecasted, and what are the advertisement with regard to anything, cigarette, alcohol, no advertisement. And there are other also, it has been given, provided. And with regard to the responsibility is the editor, nothing else. Because under Information Broadcasting Act, my lord, you have to declare who is the editor.
These things will be seen at the trial, my lord, not at this stage. This is my humble submission, my lord.
Shut up, no, no. Okay. I take the leave, my lord.
Yes, yes.
Briefly, all right.
May please, your lordship.
Ah.
In item 15, your lordship, I am representing the respondent above.
I have seen it
Item 15.
15.
Yes,
On
what?
the order of the LCR record, the case has already, LCR was called for. And the learned court has already closed this complaint petition, which was silenced before this report. In terms of that, your lordship, because it was a 406 RPC, your lordship, it's the article that has been already received by the complainant. And she filed a petition for withdrawal of the complaint date. Which
It
was
has already been withdrawn or what?
Lordship, lordship, I kindly have it. There is the LCR record.
Here you are appearing as a respondent.
Respondent. 618 order may kindly have a look, your lordship. That will
No, no, no. No, you're saying that she has already received.
receive the student and
Huh.
petition was filed for withdrawal of the complaint petition.
That order, is there any
Is
order?
there
is
order
passed?
in the LCR? Lord?
LCR is order also.
LCR is in here, your
Who is appearing for the petitioner here?
Lord.
It's Mr. B. Hussain and Mr. P.B. Mujumdar. 15 to, huh? It is 15 number. In
LCR.
LCR. You have marked it, reflected. Here order is there, na?
The order is
Order
there.
dated
Order dated 1618, your Lord.
1
618, last order of the LCR.
1 6 1 6.
That handwritten order, your Lord. Last.
It is 1 8 16.
186. 186.
Then again 14/10/2020 16 the record was put up.
Just put up for as it was called for, your Lord. 116 order may kindly.
In that case too, it has become infraction.
The party order dated 116 is concerned.
But the other side on the last occasion also most probably they remain absent. None appears before 59. None appears. You are Mr.
Elmo.
Heard Mr. Almohan, the attorney counsel agreed with the respondent, and it is submitted by him that the respondent had you were here there you were the petitioner. I mean
In the complaint.
in complaint. Submitted that the respondent herein as a petitioner had already withdrawn the case had withdrawn the case from the learned trial court below, and accordingly the matter is already been disposed of as uh, as withdrawn by the respondent. The as part order dated 160 is 1/8/16, and as per order dated 1/8/16 by the learned trial court below, it reflects that the case has already been dismissed on withdrawal. Thus, the present petition has already become infraction. However, in absence of the petitioner, this court is of opinion that nalagate uthawale fix corridor for necessary order. None economic let the matter be accordingly listed and and in absence of, and if the petitioner remain absent, the consequence order will be passed list accordingly after 4 weeks. Okay, we'll pass next. step.
My
Your-
lord, my senior K. Bhuya is not well today. So kindly fix the matter.
He was waiting. Why don't you make such kind of submission in the morning hours itself? It could have been done. Still, I'm not feeling well, but still I'm here. But the question is that could have informed. He is waiting for.
Right.
Who is your senior?
K. Bhuya.
Otherwise, definitely we cooperate. If someone is ill or advocates inconvenient, we definitely cooperate. But the question is that he was sitting, na? Anyway,
It is
you
well
are-
listed, well listed in the cause list, and it is known to them also. Nothing has been informed in the earlier stage.
Mm.
And it has
I will-
come after a gap of so many years.
the matter of 2015. Obviously, that is the issue. If your counsel, definitely, he may be, we are not on that, but the question definitely, I am also not feeling well, but still. Anyway, you are MS?
K. Hussain.
Heard MS K. Hussain appearing on the Mr. K. Bhuya. Heard Mr.
SK Bhattacharya, respondent number 2.
Representing for the respondent. Mr. Isham, additional PP paid for the statute. Submitted by MS. To ensure that Mr. Bhuya, the NK's commissioner, is not keeping the submission made by matter is adjourned. However, both the parties are hereby directed to proceed with the engagement in instead of listing, as it is a case as the case is pending since. You want to fix it here or
Fix it, Lordship, as it is pending for last 10 years.
before? 7th of January.
7 January.
I think the matters with. Oh, okay. And appears on call for the petitioner respondent to Vasily. Appears on call for the petitioner as well as the respondent.
It is.
This is the matter according to you are for the
Petitioner, Lordship. Two petitioners are there. Both both employees of IGNU.
You are for the respondent?
Out of station. Yeah.
Same situation had happened. Mr. Kothari was sitting since morning. He could have informed. Definitely, he may be out of station, so he may not be in a position. But in morning since morning he was sitting. Mr. Kothari, I found him there only. No, it's okay. He may have some difficulty. I am not on that. Mr. Doctor, if it is not available in the station today, that may be a reason. But the question is that he was sitting for that. And that too, these are all these matters of 15, 16 prior to 18, all also sorry, of 2020. This is also a old pending.
Lordship, in so far as this matter is concerned, what has happened is petitioners' promotion and MSCPs are withheld. So we have also, if the Lordship will see last few orders, we have tried our level best to get this matter listed since last 1 year or
For
so.
MSCP, how many years? This last for this.
Yeah, Lordship, 2018 this matter was stayed. So since 2022 onwards, I have tried to restructure and get this listed, Lordship. But for some reason or the other, And otherwise, Lordship, IGNOU is in support of the petitioners also. There's not much there, and not even a technical matter, Lordship. We don't have to delve into merit. The charge sheet was laid without obtaining necessary sanctions. That is the case, Lordship. If the Lordship may kindly fix a date, since today I believe it.
Mr. Vaidya, you are MS? EP does for the response number 2. However, it is submitted by MS that a encounter Mr. Peter. Case is accordingly rate for a fixed no for a fixed not again and accordingly it's a matter may be a short date may be given or a hearing. Dated you 6th of January we are fixing it.
Lordship.
Just make a reminder before the court that on that day the request was there that would make it
Lordship.
so that somehow it can be heard.
Lordship.
6th of yes, do you have any
Deeply obliged. 17, my lord. I was just running out to reach my lord.
17.
It was 15 matters, my lord. May kindly be a date, nearby date may be given.
You are appearing on behalf of whom?
Respondent.
Oh, you are for the respondent?
Yes.
Yes, for the petitioner side, they are absent, I think.
We were there 11. We were here a bit earlier.
We are done till now. I have not.
Anyway,
they are absent. Your presence will record your presence. Will record your presence.
Yes,
Just
yes.
good name.
A.Y. Chaudhary.
A.Y. Chaudhary to record.
A close date. may-
Otherwise, we are listing it at after 4 weeks.
My lord, already 15 matters, my lord. Only this is the
Obviously, because before I got Burkita Diyar, it will be after Bihu because prior Bihu we have fixed many matters. Yes. So let it be after Bihu. Prior Bihu we have fixed many matters. After Bihu, give it to Friday. 2 months, 21st of January. We'll try. Today, why Mr. Chaudhary, Ichari Chaudhary, he is absent in many matters, were fixed for him. I mean, there are many matters he was appearing, but today he is not present. He is not available today.
physically unwell. Probably.
Oh, that's, I also thought that something might be happen. Otherwise, he is very
Junior
regular.
was
when he
here
comes.
to attend. Junior was here to attend.
Acha. But that is the
So he has
reason.
come.
Otherwise, acha, acha. You are there.
I am the petitioner in this case. So,
Maybe hard, my lord. If
the
otherwise
lordship,
not.
up to your lordship, I am not.
Up to your
Lordship, otherwise.
You're not going to hear. It will be on the 21st of January. Yeah, go bare by parents. Yeah. Okay.